6 months ago, Ivanka Trump was appearing alongside world leaders at an international business summit in Saudi Arabia. Today, the situation described in filings is starkly different. She cannot leave the Southern District of New York without permission from a federal judge. Her passport has been taken, and she is wearing a GPS monitor after posting a $15 million bond. And at the center of the latest turn is Melania Trump, her stepmother, who, according to the narrative laid out in the court record being discussed, walked into a federal building in Washington, answered 147 questions under oath over 2 hours, and did not invoke the Fifth Amendment. If that sequence is accurate, the immediate question becomes simple and unsettling. What did she say that moved a judge within 48 hours? The account presented claims federal marshals arrived at her Miami residence at 6:47 in the morning and seized Ivanka Trump's passport. From that point, the restriction is clear. She is effectively grounded to the Southern District of New York unless a federal judge allows otherwise. A $15 million bond is described as the condition for remaining out of custody, paired with a GPS monitor to track movement. At the same time, the filings being referenced describe a broader financial picture. $84.7 million in questioned wire transfers, 23 shell companies across 6 states and 3 countries, and 89 structured cash withdrawals allegedly kept below federal reporting thresholds. It is presented as the product of a 2-year investigation that, in this telling, suddenly accelerated. What gives the story its sharper edge is the person said to have brought fresh momentum: Melania Trump. The description is not of a witness dragged in reluctantly, but of someone who appeared voluntarily, accompanied by a private attorney retained separately from any legal representation connected to Donald Trump or the Trump Organization. But voluntary doesn't automatically mean decisive. So what, specifically, could have changed in those 2 hours that led to immediate restrictions on Ivanka Trump's travel? The filings being discussed frame Ivanka Trump as more than a business figure with a recognizable name. They emphasize her role as senior advisor to the President of the United States from 2017 to 2021, describing a West Wing office, top-level security clearance, and access to classified financial briefings about international money flows and anti-corruption enforcement. Alongside that, prosecutors are said to be pointing to a parallel financial empire, not presented as casual investing but as deliberate structuring. Limited liability companies registered in Delaware, Nevada, New York, Florida, and 2 additional states investigators reportedly only uncovered in the last 6 months, plus shell entities in Cyprus, a subsidiary in the Cayman Islands, and a Nevada holding company described as having no employees, no revenue, no physical address, and no apparent business activity. The narrative also draws comparisons, not as proof, but as pattern recognition, to Paul Manafort and Michael Cohen, both referenced in connection with the use of entities across jurisdictions. Those names are invoked to underline an investigative idea. Layering mechanisms can be used to make money harder to trace, and the documents suggest investigators believe they traced it anyway. Procedurally, the account says a federal grand jury was quietly convened in Manhattan 18 months ago, with subpoenas to banks, accounting firms, and business associates connected to the Trump Organization financial network. It then claims the scope expanded 6 months later and that Ivanka's legal team tried to slow the process. Motions to block document requests, challenges to subpoena authority in 3 separate courts. But that 2 weeks ago, a federal judge rejected every motion and ordered full compliance. And that's the pivot. Once a judge orders every document, every financial record, every communication, the pressure stops being abstract. It becomes personal. So when Melania Trump appears in Washington with independent counsel and answers 147 questions, one question hangs over everything. Was this simply cooperation or something more strategic? And if it was strategic, who does it advantage? One detail in the account carries unusual weight: the attempted privilege argument. Ivanka's defense team reportedly challenged Melania's testimony on privilege grounds, pointing to spousal privilege protections. And the judge rejected it immediately, with the reason described as straightforward under federal law. There is 0 testimonial privilege between a step-parent and a stepchild. If that procedural point stands as presented, then the content of those 147 answers doesn't sit in a gray zone. It becomes usable, admissible, which raises the most consequential hinge in the entire timeline. What exactly is in that testimony that a judge accepted quickly enough to authorize a passport seizure and tight travel limits. The filings described break the prosecution's case into layers, starting with the money movement. According to the account, between March 2023 and November 2024, Ivanka Trump personally authorized 31 separate wire transfers totaling $84.7 million. The money is described as moving from Trump Organization subsidiary accounts through her personal business network and ending in 3 offshore entities: a holding company registered in Cyprus, a subsidiary incorporated in the Cayman Islands, and a Nevada limited liability company described as having no employees, no revenue, no physical office, and no discernible business activity. The language attributed to the record includes page 43, stating that the defendant facilitated the transfer of funds from Trump Organization subsidiary accounts to a Delaware registered entity with no apparent legitimate business purpose. That framing matters, but it still has limits. A description of layered entities and unusual routing may look suspicious, but suspicion is not the same as proof. The key question is what investigators can demonstrate about intent, purpose, and knowledge, and that's where the next layer enters. Exhibit F on page 147 is described as showing Ivanka personally withdrew $3.2 million in cash equivalents over 14 months, never more than $9,500 at a time, across 89 separate transactions, all below the $10,000 threshold that triggers mandatory currency transaction reports under federal banking law. In this telling, the prosecution treats that pattern as deliberate avoidance. But here's where allegation safety becomes essential. The existence of withdrawals below $10,000 does not by itself prove a crime. The claim in the filings is about intent, the deliberate decision to stay under the line. That is what prosecutors would need to establish. The most pointed piece described sits on page 156, paragraph 14 of the official transcript. Melania Trump testified under oath that she personally witnessed conversations in which Ivanka discussed keeping transactions below reporting thresholds. The account presents it as direct acknowledgement of the line being targeted, summarized in one short phrase: keep it under 10, always under 10. If that sentence is accurately reflected in the record, it's not a technicality, it's a claim about conscious decision-making. Then page 162 is described as the prosecution going further, arguing that Ivanka possessed specialized enhanced knowledge of federal financial reporting requirements due to her role as senior advisor in the White House, with briefings on anti-corruption enforcement and access to Treasury Department protocols. That argument attempts to strengthen the intent element, not just that a threshold existed, but that she understood it from the inside. At this point, it's crucial to separate what the filings suggest from what they prove. The documents, as described, present a tight narrative: pattern, routing, and witness testimony. Yet parts of this remain allegations surfaced in filings, and verification needed applies to anything not independently confirmed beyond the descriptions provided. First, timing. An argument framed as selective prosecution, pointing to an investigation initiated 18 months before a major election cycle. That is a legal claim, not an established fact, and it would require a court to accept that standard. Second, the intent requirement for structuring. The defense position described argues prosecutors must prove specific intent, and that pattern alone is not proof. Third, the offshore entities. The defense is described as filing 47 pages of business documentation, including international licensing contracts and brand management agreements involving companies operating across Europe and the Middle East, arguing that international commerce can require international financial infrastructure. Fourth, and potentially the most human, is credibility. The defense motion on page 23 is described as claiming the witness has significant personal and financial incentives to provide testimony favorable to the prosecution. That is an allegation about motive, and it would be tested through scrutiny, contradiction, and cross-examination dynamics that have not been resolved here. So the evidence picture, as presented, becomes a contest between architecture and explanation. Are the entities and transactions a deliberate concealment system, or a global business structure being interpreted in the harshest possible light? And that leads to the next question that keeps returning. Why did the court move so fast after Melania Trump's appearance in Washington? The posture described now appears to be driven by risk management. Passport seizure and movement restrictions are framed as tools used when a judge finds probable cause to believe a defendant poses a genuine flight risk. The account emphasizes that judges do not impose those limits casually, and that something from the testimony or supporting exhibits was persuasive enough to justify the order. There is also a broader procedural reality in the background. Once a federal grand jury is active, and once a judge orders full compliance with records and devices, the case stops being purely about theory. It becomes about what can be corroborated. Live testimony can be powerful, but in federal practice, the most durable cases tend to be those where documents and devices align with witness accounts. And there's an additional procedural point described as already resolved, the privilege challenge. If there truly is zero testimonial privilege between a step-parent and a stepchild in this setting, then attempts to exclude Melania Trump's statements on that basis would fail, leaving the defense to focus on credibility and alternative explanations rather than suppression. So, in plain terms, the legal tension is this. If the paper trail and device material match the testimony, restrictions tighten and leverage increases. If they don't, the defense gains oxygen, and the story changes shape. The timeline in the account is specific, and it is close. Wednesday, February 11th, a status conference in federal court. Ivanka's attorneys are expected to argue for modification of her travel restrictions, removal of the GPS monitor, and expanded movement boundaries beyond the Southern District of New York. Prosecutors are expected to oppose those requests and may present additional exhibits. If those exhibits include material tied to Melania Trump's testimony that has not yet been made public, the hearing could shift perceptions quickly. Thursday, February 12th, the federal grand jury reconvenes. The account notes the indictment scene may not be the final version. Grand juries can add charges, expand scope, and name additional defendants. It also states 23 individuals have been identified in the investigation and not all have been charged. Whether that remains a narrow case or widens is one of the most consequential unknowns. Friday, February 13th. The court-ordered deadline for full device compliance. Every laptop, every phone, every tablet connected to Ivanka Trump must be surrendered to federal investigators. The account frames this as an inflection point. Deleted messages, encrypted applications, timelines, all of it potentially recoverable and testable against what was said under oath. So the forward question isn't abstract. It's time-stamped. When the Wednesday hearing ends, what will the judge accept as sufficient? And when Friday's deadline hits, will the devices corroborate the account given in Washington or complicate it?